of obstruction or retaliation, a third-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. Mr. Rojas, Mr. Douglas, come back up. Is there a, I need the certification. Kaylin Douglas. Yeah. Kaylin Douglas. It should have been with, oh, never mind. Did I print it? No, I haven't yet. I kept it. That's why. Okay. All right. So just for the record, and I've gone back to review the pre-sentence report just to remind myself of what was in that and kind of what got us where we are now. And Mr. Douglas, I hate this because I really, really, really wanted you to succeed. I really did. I wanted you to be able to go to ISF, but I can't not stick to my word. I told probation when you were here. I told you when you were here, no more incident reports before ISF or you're not even going to make it. And it has been 1, 2, 3, 4, 6, 7. What day were we here? Dozens, at least. The sentence date was supposed to be, the sentence date was November 18th. So since November 18th. You've been caught with looks like kind of a makeshift tattoo needle. We've got 1, 2, 3. Four or five at least times when you have been exposing yourself while masturbating to the officers, spraying other inmates with disinfectant spray, horse playing, smoking. I mean, it's just.
Judge, I certainly understand your thoughts about it not being enough time, especially with the incident reports you're having a problem with on all these people in the jail.
No, I think I'm going to go along with what you guys have agreed to. I just wanted some time to look at it. That I'm just reminding myself of all. I mean, the fact that you got this in the first place, because we went through. I have it all marked off on this PSI. Your juvenile history and the opportunity you were given now that you're an adult to change your life and just follow the simple rules. So I am going to, let's see. So I have documents here on this tablet that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand if I go along with this agreement that you're waiving any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, Mr. Douglas, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence at this time to find you guilty. Okay, something wrong. Find you guilty of obstruction or retaliation, a third-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rojas. And so today, just Mr. Douglas, just because you got time today does not mean that you still can't do better and change your life. Better you act in prison, the sooner you're gonna make parole. The sooner you do that, you can get out, hopefully follow the rules and have the best life you can. You get in TDC and act like you've been acting in our jail, you're gonna end up doing the whole 4 years. But you're eligible for parole in less than 2. In about a year and a half, you're eligible for parole. And that's gonna be 100% up to you. And I can assure you, you're not gonna get it if you keep acting like this. All right? You can go back with the bailiff. Good morning. Are you Khalil Bradley Harris?
Yes, ma'am.
And Mr. Bradley Harris is charged with unlawful possession of a firearm by a felon in cause number 25 DCCR 1334. And Mr. Lane, what is the announcement?
Your Honor, I came into the case late and went over discovery. I apologize to Ms. Malvino. I have a media request, but the main officer, Miss Champagne, does not have her body cam. As a list, she says she has her body cam. There's like 8 videos of this stop. And it's a very important video because it shows some incidences, whether there's a suppression hearing and where the gun was found.
So
and
do y'all
things like
have
that.
it or is it?
Judge, I'm sorry, it was late yesterday when he brought
Oh,
that to
okay.
my attention. If it is not on the thumb drive included, my file didn't reflect a media request, so I'm glad at least he has.
Yes, I've had the
Majority of
discovery.
things. I will
Okay.
take a look at the thumb drive I have, and if it's not on there, I will reach out to her myself.
Okay, I'll just do a normal reset. Mr. Bradley Harris, that will give Mr. Lane time to get all of the discovery. He'll come out, I'm sure, and go over all of that with you and we'll get an announcement at the next court date. All right, thank you. You can go back with the bailiff.
I think our system's operating.
All right, you are Heyman Brandon Jr.
Yes, ma'am.
This is cause number 21-36605. Mr. Brandon is charged with the first-degree felony offense of murder. Looking back at the file, which I'll take judicial notice of, it looks like Mr. Brandon was previously found not competent to stand trial and then sent to the appropriate facility. That looks like the Terrell State Hospital. And let's see, so are we now? I have received a report dated January 20th of 2026 from that facility with the finding that Mr. Brandon is now currently competent to stand trial. That evaluation includes a evaluation report, trial competency evaluation report that was prepared by a Dr. Jasani. The finding in that is, again, that Mr. Brandon is competent to stand trial. And that he is able to move forward with his criminal proceedings at the present time. That was also signed off on by a Dr. Lampley as well. So I have both of those doctors saying that he was currently competent to stand trial. We got him back and we're here now. So what is the announcement?
Your Honor, what I did was I kind of challenged that. I thought I was going to challenge that. So I sent Dr. Gapon out because we were having a hard time communicating even when he got back to the jail 3 weeks ago or so. Dr. Gapon went out, also corroborating the fact that he feels like he's also competent.
Okay.
So I reached out to Mr. Smith, who is still dealing with the family. I'm still dealing with him, which is going to take a little time. I have a insanity evaluation that's also being done by Dr. Gapon. If we could have a somewhat of an extended announcement, then we could come back and be prepared. I'm literally asking possibly, Governor Smith, for possibly a bench trial. The things
So
that-
let's do this. What I'll do then, based on that report, as well as the your statement that Dr. Rapon is also going to, and I believe I do have a copy of Dr. Rapon's report. It was probably meant to be sent to you, but it was sent to the court.
I asked them to send you a courtesy
Okay.
copy so we could kind of see where I was
Any
thinking.
objection to me taking that into consideration with regard to competency as well?
There you are.
So I'm also going to take judicial notice then of the competency evaluation report prepared by Dr. Rapon. It's dated February 12th of 2026. Again, it has the finding that Mr. Brandon is competent to stand trial. Based on both of the reports from Vernon's as well as Dr. Rapon, I'm going to at this time find that Mr. Brandon is competent to stand trial. And what I'll do is I'll do about a 45-day reset to see where we get at that time. And then we will see if we can get an announcement at that point.
Yes, sir.
All right, you can go back with the bailiff, sir.
Brandon, I'll be-
Good morning, you're Dalton Batiste. Answer out loud.
Yes.
And this is cause number 24 DCCR 0917-0918, 25 DCCR 1436, 1437, and then 24 DCCR 0407. Mr. Batiste is charged in the first two cases with murder, the second two with manslaughter, and the last with possession of marijuana. And what is the announcement?
Judge, we're still ready for trial, so.
The state's ready for trial as well, Judge. We would prefer to proceed on the felony possession of a marijuana case first. I understand the court if there's pushback from the court on that, given the fact that it's a state jail.
I'm not doing that.
No.
There's no way I'm gonna try a state jail felony on top of the other cases, so. So what are we actually, this is just an announcement. Did we get off the trial docket?
Yes, Judge,
Remind me, please.
Yes, we tried this case. We had a hung jury.
Yes.
And the state elected to re-indict as a manslaughter, using the same theory, essentially as before. But the challenge is, of course, I think you said it on a review or whatever this is, because that's essentially a totally different charge than the fentanyl murder statute that we were arguing
Right.
about last.
And I'm fine, obviously, I would, if the state's going, I guess I'm a little confused. Two murder charges are still pending, and typically when something.
I filed dismissal on those. This morning.
Perfect, okay. So actually, we're just looking at the two manslaughters and the possession of a marijuana
That's
case. So I would, let's get it set then for a trial on the two manslaughter cases. And then, let's see where we get from there.
Judge, the state's also filed a motion.
Yeah, let's talk about that. So, Mr. Batiste, Mr. Coleman has filed a motion asking that I order you to act in a certain way out at our jail and to follow the rules and all of those things, which you should be doing anyway. I feel like we've probably already had this conversation, but what I can do, and here's what I don't necessarily want. I don't disagree with Mr. Coleman a single bit. You can ask Mr. Gertz, you can ask anybody that's been in front of me about how I feel about what is going on at our jail and how disrespectful inmates are being to the staff out there. And I'm doing whatever I can to try to get through to you all, because it can make things much worse. Much worse. Number one, if you go to trial on the manslaughter and you're found guilty, the jury's going to hear about all of it. They're going to march these correctional officers in here and they're going to say what you've been saying to them, that I'm not going to say today because a lot of people are watching. But you know what you're saying. You know how you're acting. I can promise you, Mr. Gertz is embarrassed for you because you don't help him help you by acting this way. Does that make sense? You're not one of these kids out there. How old are you? 26. So typically I'm dealing with 17, 18, 19-year-olds that are out there acting crazy. You're too old for that. What I don't want to do, Mr. Coleman, though, is cause the jail more grief by holding him in contempt and making him stay there even longer.
And-
Here's what we're gonna do. We're getting the case set for trial on the manslaughters. We're gonna get those tried. I'm not sure what I will do if you violate this exactly. I can't tell you right now, but I am ordering you to refrain from calling names. And if you need me to tell you everything, I can. If I need to be specific, I'll be specific. Because what I don't want you to come in here and say, well, I didn't say bitch, I said whatever. You know what I'm saying? Behave. Don't call names. Don't tell them they don't have rank. Don't tell them I get what I want. B. That's not how you talk to somebody who's just going to do their job. They're just trying to go do their job and go home. And they got to deal with you and all the other people out there that are acting like idiots. So I'm going to order you to not do that. What that means is if you violate that order and do it, and I get more incident reports, Mr. Coleman will ask me to hold you in contempt. And what I can do for every single incident, for every name you call, for every time you get written up, for every time you don't follow the rules, I can hold you in contempt and I can order 6 months. And then I can stack 6 months for every name. Every time you say it, I can stack it, stack it, stack it. Do you understand? So you are now court ordered to follow the rules, which I shouldn't have to do, but I am. Okay? So I will set these cases for trial at the very next trial setting that we can get them on, and we'll go forward at that time. All right,
Thank you, Judge.
you can go back with the bailiff. There you go. Good morning. Are you Jonah Johnson? This is 25 DCCR 1775. Mr. Johnson, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from August 31st of 2025. And what that means, sir, is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
Can you check if there's any of his in that pile? I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Mr. Johnson, Ms. Holmes has been appointed to represent you, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Ms. Holmes, you are released. Mr. Johnson, we will appoint someone today. They should be out to the jail very soon to begin preparation for trial. All right? And there's none. And just because I get on to everybody for having incident reports, thank you for not having any incident reports. I mean, right? I feel like I need to, seriously though, it can affect your case. It can affect how the DAs look at your case. It can affect how a jury looks at your case. Continue doing what you're doing in jail, following the rules, because that's only going to benefit you, okay? All right, you can go back with the bailiff. Ma'am, are you Almeida Miles? And Ms. Miles, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Miles, in cause number 24, DCCR 2330, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation September 16th of 2025 for the offense of tampering, fabricating with physical evidence, a third-degree felony, and that was a 10-year deferred probation. Is that correct? The motion alleges you violated your probation. Count 1 alleges that you failed to.
Some of them are kind of redundant.
Okay, well,
Those
let's.
counts.
We'll start with this one, then we'll see. So count 1 alleges that you failed to avoid injurious or vicious habits, in that you physically assaulted another offender in the B3 pod on or about the 6th day of November 2025 at the Henley unit, which is the ISF unit. Is that true or not true? True. Count 2 alleges that you failed to complete the education program, the GED program, because you stated that you were tired and did not feel like going to school so early in the morning every day. Is that true or not true? True or not true? Sounds ridiculous when you hear it read back to you, doesn't it? Count 3 alleges that you failed to enter and successfully complete the ISF program, and that you were removed based on behavioral issues. Is that true or not true? Count 4, well, it's different. Count 4 alleges that you failed to comply with all of the directions of the ISF program and that you engaged in sexual misconduct while participating at the Henley Unit ISF. Is that true or not true? And then count 5 alleges that you failed to comply with all of the directives of the ISF program and that you were walking around in the quote living area of the dorm during count time against the rules. And that's also at the Henley unit. Is that true or not true? That one's not true. So did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation. What I would like to do, I'm going to reset it. I don't know that I need, because she really hasn't been out, a full update, but I would like as much information as we can get from ISF. So if they have reports that you guys can get your hands on so that I can read more about what went on there, that will help me, I think, with sentencing. Anything that you think is important for me to know, get Ms. Holmes will be out there to visit with you, tell her all of that. She'll present it to me on your behalf when we come back for sentencing, and then I'll decide what to do. All right, you can go back with the bailiff. Oh, wait, come back for a second. So, Ms. Miles, I do want to make sure you understand, obviously, it's important how you behave when you're in custody. And so anything that happens between now and when you come back for sentencing in our jail is only going to make things worse. So my suggestion is you better get out there, you better lay low, and you better follow all of the rules, because anything that I might be thinking about doing is going to go up in years if you're out there misbehaving. Okay, go back with the bailiff. Yes.
We gotta get home.
And are we going on count 1 only?
Yes.
Yes, Sharon. Good morning, sir. Are you Eric Wara? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Wara, in cause number 24 DCCR 2344, the state has elected to proceed on count 1 only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from October 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wara is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with that agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in this case. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Phipps. All right, good luck to you, sir. You can go back with the bailiff.